So, John, I have a really important question here. I see that there's some fields that are empty. And what do we do when some fields are not applicable or just empty for now using the Visas.ai platform? Do we fill them out? Do we leave them blank? As an attorney, what would you do? Or what would you tell an attorney using this to do?
Yeah, somebody else has been playing around in this and put things like, what is the name of the new commercial enterprise, and NA. You would never leave that NA. You can't get a visa approved without a new commercial enterprise in it, right? So NAs are used in immigration when they really are not applicable. Like, what's your maiden name, if you're male, or something along those lines. You would put that. Leave it blank if you don't know it, and find it out, right? So you can put notes if you want in these, but whatever you put in this is going to drop into a brief, right? So I would leave it blank and use the comments over here, right? So when we're working with it, you got attorney, you got petitioner, beneficiary. So we're going to let all of them see there and say, we don't have a name of a NCE yet. We'll put in when we do. So new commercial enterprise, what that means, a new commercial enterprise under EB5 law is the company that you are investing into, right? You're not investing in a regional center. The regional center is a designated area. The company is going to be the project, right? So if we're going to build the stadium in the blighted area of Kansas City, that stadium might be called the Kansas City Basketball Arena or something along those names. So that's what you'd put in. You put Kansas City Arena LLC, right? What's the location of it? Inner city, or let's call it 123 Oaklawn Ave, Kansas City. Missouri 34567. Apologies for me, Missouri. I know that's probably not the area code, but I'm just making it up. Okay. All right. So what evidence supports CSC within the target area? Okay. So this is waived if a regional center. So somebody asked that question, you need to look into it. Okay. So you can always put that sort of stuff. So the way to do this is what I would do to determine something's a regional center. Look, we have a blue thing here. This is going to take us to our this is our winning strategies, and I added some winning strategies, but they don't look like got in there. I need to go back and check those, but there'll be a winning strategies on the target employment areas. Let's see what we got here under examples. Okay. The NCE is located within a rural area which complies with the regulations and policies of the target employment area pursuant to USDA policy right here. So here's the policy. You can click on that. Which states? For petitions filed on or after March 15th, 2022. Remember, I was telling you it's about a year ago. USCIS designated TAAs are valid for 2 years from the date of investment, or standalone investors, or 2 years from the date of regional center property files the I-956F. Remember, we talked about filing for a regional center is like filing for a visa. That is done with a 956F. And may be renewed for 1 or more 2-year periods. An immigrant investor who has invested the amount of capital required for a TA during an approved designation does not have to increase the investment if that designation expires, right? The grandfather, and we talked about that. So the area question qualifies as a TA at the time the investment is made, or the immigrant petition 526 is filed, whichever comes first, but may cease to qualify by the time the petition for investment to remove conditions, as we talked about, right? So these are some things there. So to determine if it is a TEA, there are a lot of organizations that used to do this designation, and you can look at that, but it needs to be rural, right? Which means it can't be in an MSA of a city. And I believe it needs to be in counties or cities of less than 20,000, right? 20,000 is a city. High in employment, they have some new regulations around that. and that's going to be, I believe it's 1.5 times the national unemployment average, right? So if the national unemployment average is, well, I can't do math, but 1.5 times whatever that is, and then what was happening is that people were connecting tracks of a high unemployment rate to things that weren't. Now they have to be contiguous, right? So you can have a track and the track next to it can count, but you really want to get with somebody that can determine those TEAs for you. And there's some entities out there that can do that for you. And if you don't know, shoot us an email. We'll help you understand that. Okay. So then the next thing we talked about, the economic impact report, right? So these are, you want to use an economist with experience in providing job estimates using methodologies that's been approved by Visas.AI and EB5 regional center cases. That is really, really smart. Don't try to get somebody that hadn't done this to tell you what the economic impact is going to be for a regional center if they haven't done it before, right? So they've got some, this is the new law on it, this is the regulation on it, but that's what you want to do, get an economist to talk about the indirect jobs. Now, the regional centers lawyers will have done this already, right? A regional center is going to tell you if it's in a TEA. They're going to have a TEA designation. And what we want to ask them is, have you already had visas approved with this as a TEA, right? Under this new law right now, the new law is only a year old. So some of them may not have had them done yet, right? These visas sometimes take a while to get approved. So that's going to be the question. And you're going to have to look at that and do your own analysis under it to put your client in that scenario. And take a look at their economic impact and say that. One of the things you want to know as a lawyer is you don't want your client's case to get it denied, right? So basically it's 10 jobs for every employee, every investor, right? So you don't want to be the last guy in. You probably don't want to be the first guy in, because if the project doesn't go off the hand, right? You want to be nice in the middle and towards the end probably. But what's the buffer on jobs versus investors, right? So if there's going to be 100 investors, that's 1,000 jobs, right? So if they say that we're going to create 1,000 jobs exactly, and you're the last investor, and then they don't make it by a job or two, your visa gets denied. So many of the good regional centers projects will have a buffer, and they'll say we have a buffer of X%, and that'll be in the economic impact analysis, and you can look at that. So that's how many jobs will be created by the new commercial enterprise. That's definitely not an NA. That's going to be a real one. So let's say it's going to be 1,000 jobs, right? We're going to look at their economic impact to say that, and we can have issues there. So less than 10 full-time jobs and not be the regulations. So right here, guys, here's OV helping you out and giving you a warning if you get the wrong number. Increased earnings. This will also be an economic impact statement. We talked about this before, describing the EB5. Oh, the beneficiary. Okay, so EB5 is a citizen of India, has a tech background. He has created an information system that's now licensed and used in 20 regional hospitals in India. He's made an equivalent of 200,000 USD last year and has a home worth of 150,000 USD. He's committed to the regional center in the U.S. As it will be counseling service. He believes he can expand his own business in the U.S. market as well as supporting the U.S. economy. Right. So there's a little overview. So what I like to do and why we write briefs, attorneys, is that it gives us an opportunity to give it an opening statement, right? I think a lot of immigration cases are merely a table of contents with no analysis, right? This is our opportunity to be lawyers, right? So put your investor in the best light. Make sure they're a human, right? Let's talk about them. Let's talk about the successes they've had and why, from looking and reading this this is a good idea to have this guy come to America. That's what you want to do. So that's the reason of describing them. He's going to invest 900,000. That's 100,000 over the TEA level. Now his investment, he has 450,000 in savings. He's ready to invest that. He's obtained a loan from 123 Bank for 450,000 for the investment. Okay, so what you need to know about the source of funds, right? This is what this is, right? Is that shoot some hints. So there's all sorts of hints on here, and you can read over these at your leisure. But that's why we got OV over here telling you about source of funds. The most important thing for a beneficiary is proving their source of funds. And not only the source of funds, but the beneficiary. But if the beneficiary is borrowing the money, you have to do the source of funds for the lender unless the lender is a bank. So this is a bank, you don't have to prove it. But if it's Uncle Joe, right? Uncle Joe's going to have to show his source of funds, right? And these are all the different things. And there's a lot of things that go into it. So 3 years of bank records. What's that?
Yeah, John, is this to prevent terrorism or money laundering, or what is this for?
Yeah, what they love to say is we don't want drug dealers' monies, right? That's what they used to say. So it has to be clean money, right? So clean money is it can be clean money. It's still hard to prove, right? And it's funny what they won't let you do. You can borrow, you can have a gift from an immediate family member, but you can't have a gift from a friend of the family or an extended family member like an uncle, right? Even if you're raised by your uncle, that won't work. It has to be a loan from them. But if you're going to borrow money, you have to secure it with your own assets, not the assets of the company. So again, you can do an EB-5 with your own company, invest the money in your company, then go to a bank and get a line of credit. But regular lines of credit to banks are going to always be secured by the company's assets. If the loan is secured by the company's assets, it will not work in an EB-5. Now, a regional center EB-5 is somebody else's company. So that's not usually it. So you take your house and then you take a loan against your house and then you give it to the NCE, right? The new commercial enterprise. All right. So that's what he's going to do. So this one's good. He's got $450,000 in the bank and he's got a loan. He's going to take the $900,000 and he's going to give it or loan it. I'm sorry. He's going to invest it through an investment vehicle. What I mean by that, a document with the what we're going to do, the Kansas City Arena LLC, right? So Kansas City Arena LLC will enter into an agreement. Now that can be just your typical equity play. I'll give you 900,000 and I'll receive 2% of the company, right? At, a 1% interest per year. And now there cannot be a guarantee that you'll get that money back if the company fails, right? You have to be at risk. However, they are allowing guarantees that if your Visa fails and the company succeeds, you can get your money back. If you pull your money out, you can get your money back. So regional centers are providing those sorts of guarantees, and you'll see different guarantees from them, maybe corporate guarantees, maybe even individual guarantees on that. But again, can't guarantee it because the company fails. Only guarantee it if your Visa fails without the company failing. All right, so there's a couple things. So source of funds, good practice idea. Have a CPA analyze the source of funds for you, lawyers. So the statement can say, I attest that Mr. 5 has $450,000 in his XYZ bank account. As of September 10, 2022, and that he has secured a $450,000 line of credit and providing him with $900,000 of capital to invest in company. I can attest that he, in fact, invested the company by reviewing the executed investment documents and reviewing the wiring of 900,000 from his XYZ count on December 31st, 2022. Okay, so something like that is a very, very solid piece of proof in which you brought in a professional who has put his licensed opinion in there to do that, right? Now, will you be filing a adjustment of status petition with this? Let's say yes. Now, we talked about this. This is very, very big for Indians right now, right? Indians who are on EB2s or EB3s have priority dates 12 or 15 years out, right? And so that means they have to wait until that priority date becomes current for them to file an adjustment of status. However, EB5s in TEAs are current. And in the current ones, the rural ones are getting expedited processing, right? So because it's current, they can file their adjustment of status at the same time. They also, if they filed an I-140 before, and that I-140 was approved, then it has a priority date. So they can use that priority date also. So if they want to do the more expensive non-TEA investment, maybe into their own company, and they have a priority date that is meets that. And I think that one is 13 months out as of the date of this. So as of the May 2023 visa bulletin, for Indians, it is about 13 months out on the priority date for regular EB5s. The TEA or EB5s are current. What that means is that those who filed I-526s 13 months ago can now file their adjustment of status. The exception to that is if they had a priority date from a previously approved green card, like an I-140, they can use that priority date. So if it's more than 13 months old, then they can file in any region, in any EB5 category. But if they haven't, then the EB5 category, they can file adjustment of status, meaning that they can change or adjust their status from, say, an H-1B to a EB5 green card. They can do that in the target employment areas, meaning rural or high employment or infrastructure. And that would allow them to file the adjustment of status documentation, which includes a work authorization card. That work authorization card should come in probably 6 to 8 months. With a work authorization card, they will legally be able to continue to work on their H-1B, but also work job.
I interrupt you in the middle. Sorry for that. But what about unreserved EB5, which has a priority waiting time for India? That category. I'm looking at the visa bulletin, and it's still June 1st, 2018 priority date for India for unreserved fifth category.
Yeah,
what does it mean?
I literally just said that. So if they, what that means is if for the unreserved, so non-TEAs, have it's about 13 months out, right? That's what 13 months from now is June.
From 2018, so five years.
Oh, it's 2018. I apologize, Alex, for correcting me. So yeah, so that's 5 years out. And I'm sorry, it's 5 years.
5 years. And for China, it's from 2015. It's almost 8 years out. Okay.
So the exception to that, thank you for correcting me on that date. I thought it was 13, 5 years and 8 years for China, is if they filed an I-140 and their priority date is before those dates, so before 2018 or 2015 for China, then they can use that priority date for the EB5. That priority date can be used, right? So they could do those. So what this means right now, why this is such an exciting time for EB5s, is that these other areas are current. And that's where we're getting an infusion of investment into high unemployment areas and into rural areas, right? Which is really where we want to create jobs in our economy in addition. So thank you, Alex, for bringing that up. But that's how you would do that, is if you have an already approved I-140 and you're waiting for that. So reason to do that is that if you're 5 years in on a 12-year wait, that's, another 7 years to wait for your EB3, and you could file this now and adjust your status immediately. That would be the reason to do that. even for that one. But if you have a regional center, then bam, you go. Regional center TEA. Okay, so thank you on that. So so on the removal of conditions, it says make sure the regional center is managed well for 2.5 years. I don't know why that's in there, but somebody put those notes in there. The removal of conditions is going to be you want to make sure it's not that the regional center is managed well, it's the company, right? So somebody put this note in there, the company. So you don't get to remove your conditions on an EB5 if the company is doing something that's substantially different than what the business plan said it was going to do, right? So business plans are really important. They have to be compliant with matter of hoe. And what you have to do is do what you say you're going to do, right? I mean, so if the project is that it's going to build a tech company, and they decide in the middle, we're not going to run a tech company anymore, we're going to open a restaurant, that would be substantially different, right? And then when you do your removal of conditions, you got to show what you're doing. And if they see all of a sudden all these tech workers are now restaurant workers, they're going to deny the case. And that's one of the things. Okay. All right. So that's where the issues are right here. That's a good idea. But the regional center being managed well too could also hurt it. So a regional center could go into non-compliance. So you really want to make sure that whoever the regional center operators are and whoever is operating the company are good quality people that you check out and you do their due diligence on. All right. So, okay. So once we do that, how are we doing on time? We're getting right there. So let's go to build case. Okay. So let's quickly go to build case. You can see we got the regional center brief. So that's where you can build the brief out. All the things will drop into that. And we have the business plan template. You can actually write an EB5 business plan. Now, if it's a regional center, they're probably going to have one. And we will have the 526s and 829s uploaded this week. So I think on that, Gabby, back to you.
All right. Thank you for that great presentation. I would love to, open it up to the group. We got a couple minutes left and we can just open it up to questions and parting thoughts.
I love it. Excellent. I wanted to ask.
Oh
yeah, yes, go ahead. I'll go.
I apologize. I didn't mean to interrupt. I have a quick question, John. So what if we have, let's say, a scenario where the applicant is of Indian descent and they have ancestral land that's not in their name specifically. Oh, sorry.
Two people were talking at the same time.
Yes. Oh, me?
Yeah, I couldn't understand.
Oh, sorry. So if somebody has a name, somebody has land that they want to borrow against, or they want to show that as collateral, but it's not on their name, but their parents' name. Can they? What would they have to do in that situation? Do they have to just get a transfer, or like a quick claim deed, transferring it from their parents' name to theirs, or?
Yeah, I think there's two options. One, that the parents could quit claim the property to them, and then they could borrow money against the property or sell the property. Or the parents could borrow money against the property and then gift the money to them. Parents are direct relatives, so they can gift money to the beneficiary. So either of those options would work.
Okay.
But more complicated, not a parent, right? So change that to an uncle or a friend of the family. No, immigration will never understand that an unrelated person is going to give a substantial piece of property or money to somebody they're not related to. They just won't believe it, and they won't permit it, whether they believe it or not.
Thank you for that question.
Right.
Yes. So I wanted to acknowledge Mr. MRI Chaudhry joined us on the call today. Thank you. You're unfortunately popping in right as we're wrapping up today. But happy that you joined us, and we'll definitely love to see you again next week if you're able to join us. So on that note, thank you, everybody. We had a great collab today, and I would love to see you guys again next week.
It's great, everybody. Have a great weekend.
Thank you.
Bye.
Bye, everyone.
Bye,
Thank you.
everyone.
By Alex, Ben, Billy, Yash.